guys. All right. Well, good morning. Welcome to Judiciary Non-Civil. We'll begin with Whip Bodie leading our invocation today. Will you hit your button, please? All right. If you all please pray with us.
Thank you, Mr. Chair. All heads bowed. Thank you, God, for giving us this opportunity again to work on behalf of the citizens of the state of Georgia and just to get through hard issues and work together and try to just come to a great compromise. But God, thank you for this opportunity to serve, and thank you for all these members of this great committee and all of our allies and our friends in the room. Thank you, and amen. Amen.
Thank you. All right, so we have several bills on the calendar for today. What we'll do is, I know a couple of folks have other conflicting meetings, so we'll go ahead and take in the folders is House Bill 576. Representative Williams, do you want to come forward? All right, Representative Williams, if you could just give us a minute for us to get all the folders handed out. Yes, sir. All right, very good. So this is the substitute that's in the folders is LC 289667S. Is that the correct bill? Very good. All right. Representative Williams, we will recognize you and Ms. Nesbitt as well this morning. Ms. Nesbitt, if you want to pull that other microphone towards you, turn that on.
Okay.
All right. Thank you, Representative. Go ahead.
Okay. Good morning. Do I need to press a button or anything?
No, you're on.
Okay. Good morning, committee. I present to you House Bill 576, and all this does is changes the order of and where the Brain and Spinal Injury Trust Fund is receiving disbursements from fines. Right now it's number 12 on the priority list. By the time the fines get down there, there's nothing left for this. This is the only fund that's been approved by constitutional amendment. This does not with our proposed priority list moves it to number 4. It does not impede any of the other funds that are retirement funds that would take special legislation to do. So this that's just asking for your consideration that you look at this, and if you have any questions, Ms. Nesbitt will be glad to answer them.
Are there any questions from the committee?
If you'd like for me to go over the handout, I'll be glad to do that so you can kind of tell what we're doing here.
All right, number 13, Representative Bodie.
Yes. First of all, Representative Williams, great bill. The only question I do have on lines 21 through 23, I understand that we have notated driving under the influence and reckless driving for purposes of the fund, the trust fund. And the chair may be able to indulge as well. Isn't the super speeder also a super speeder violation also connected with the trust fund? I mean, I'm just asking because I don't know for sure.
No, the
okay.
Super speeder fine goes to the Georgia Trauma Commission.
Okay.
And this add-on for Brain and Spinal Injury Trust Fund comes from DUIs and reckless driving.
Okay. Thank you so much for the clarification.
Thank you.
All right, Chairman Setzler.
Thank you, Mr. Chairman. To the author, appreciate your presentation, and to Ms. Nesbitt, thanks for that. This is fantastic information. This really answered the mail. Mr. Chairman, in subcommittee, the debate kicked off and seemed sort of difficult to get to consensus, but I think the parties worked amongst themselves. One of the questions that did come up that we've confirmed is because the retirement systems in question are not changing their rank order here at all, there's no fiscal impact. It doesn't become a retirement bill because those are not impacted financially. And just for members, the way this works is as the tack-on fees are added to these costs of folks in the court system, number one would be paid out entirely before it moves on to number 2. It would be sort of a cascading effect. So 1 would be paid out completely, 2's paid completely, 3's paid completely. There's not a splitting of these across the 15. So where you stand in this rack and stack order is very important. But we've not changed retirement funds. We've simply moved brain and spinal injury trust from 12 up to 4 behind those set funds.
And with that, what was the recommendation of your subcommittee?
It was a unanimous do pass, Mr. Chairman.
All right, thank you. Any other questions for the sponsor, Ms. Nesbitt? Number 16. Is that Representative Chairman Fleming?
Thank you, ma'am. So when Chairman Powell passes out a bill of his committee, he adds in language that takes off all fees and add-ons, like we have on the floor today with the window tinting bill. He knocks some money out of all these.
That's correct.
Okay, thank you.
All right, any other questions? All right, we'll entertain a motion at this time. All right, there's a motion do pass and a second. Any discussion, amendments, questions? All right, hearing none, we'll call the question. All those in favor signify by saying aye. Aye. Any opposed? All right, passes unanimously. One thing I failed to mention is we should have Rules Committee sheets actually here with us in the room today. I know you have to run, but if you would come back after you finish or come to my office 131 and complete the Rules Committee sheet, we will submit all the Rules Committee sheets for my committee. So you don't have to worry about that. You have all the signatures that you need, and we don't get calls to the committee about where's the Rules Committee sheet. So,
Okay, perfect.
so if you would take care of that, or maybe Ms. Nesbitt
I'll get it
can
for
help
you.
you with that. So, all right.
Thank you very much, committee.
Thank you.
Mr. Chairman.
All right, very good. The next bill we'll call is House Bill 885. Representative Petrie, you can stay where you are or come forward, whatever you'd prefer. All right, if you'd like to go ahead and proceed whenever you're ready.
All right, thank you, Mr. Chairman. And it appears that many of the individuals on the subcommittee are here this morning, so I will try to be as brief as I can. This is LC 412402S, a bill that does really two things. First of all, it makes it clear that in the interest of providing information on an inmate's disciplinary records while incarcerated for the purposes of a DA responding or choosing whether or not to object to parole, it removes that information as a state secret as it currently is. The second thing that it does is make the entire record available to the DA upon request for certain crimes. And so there have been times in the past where that information was made available by being declassified by the Commissioner of Corrections, and then there have been times when it wasn't available. And so regardless going forward of who's the commissioner, this would make it clear that this information, that the chief law enforcement officer in our communities has access to this information in order to make an educated objection, if they so choose, on the release of a violent criminal. Having said that, I will point to line 18, which yesterday I handed out an itemized list. There's 19 crimes that we're expressly circumscribing here that are dangerous sexual offenses committed against children. And then on line 28, you will see we refer to the 7 deadlies. So it's a circumscribed list of the very violent crimes only. This is not for all records on all inmates being considered for parole of all crimes, but just for violent crimes committed in the community. Moreover, in the interest of trying to make sure that we got unanimous support, as we did yesterday, we've tried to make sure that we've added some additional language here. First of all, this information is only going to be available after January 31 of 2010, which is when the Department of Corrections moved to a new system that they currently use, a system called Scribe. And they had explained that it was going to be a burden to electronically get the data going back before that time, so we've made sure that that will not be a burden. And then finally, as we were helped to perfect this in subcommittee yesterday. We've made sure not only that that information, as is currently, is confidentially offered to our DAs. They cannot disclose that publicly anyway, and today they're getting that information in summaries and they can't disclose it. But we've even made it stronger by making it a misdemeanor penalty if they were to publicly disclose the information. So I think we've tried to work to hear all sides and to create something that hopefully will be ideal policy. Thank you, Chairman.
Thank the sponsors' work on this and thank the other advocates that have worked to collaborate to find the best possible language here. I'll recognize Chairman Reeves for a subcommittee report.
Thank you, Mr. Chairman. Thank the author for the bill. One of the policy issues that we really had to dissect in this, and what we spent a lot of time in discussion about, was the confidential nature of this information and the boundaries and parameters to maintain the secrecy of that. And there is obviously good driving public policy behind why that would need to be the case. And I applaud the representative to steal a quote from our prior chairman, Rich Golick, a balanced approach, in that while we are mandating that more information be provided, we've also placed more accountability to the handling of that information by inserting a criminal penalty in what would be the illegal dissemination of this information. And that's honestly significant. And it creates an enormous duty for a district attorney's office that obtains this information to ensure that it is cared for properly. And I think that we have reached a good policy balance on this. And if I recall, it passed unanimously through subcommittee.
Yes, sir.
All right, number 14.
Thank you, Mr. Chairman. So a quick clarification, and you might not be able to answer this. I know we spoke offline about this, but could you or somebody in the room verify that the inmate would have the same access to all the information that you're trying to do to this bill as well, and it wouldn't be impacted about what type of information they would have access to?
Yeah, that might be best answered. I could, as I mentioned earlier, I could answer you the best of my ability, but might be best answered by some of the folks that are here with the defense attorneys.
I'll recognize Chairman Reeves, who I believe can answer that question.
Okay.
Yes, and there was discussion about that, and the current existing law only allows the information that currently right now DOC provides this information. It's just in a summary format. This bill is an effort to merely expand it from a summary to a more detailed format. That information currently is only eligible to be given to the district attorney, and we talked about this, and I don't know, I guess some of this is speculation, but the driving force behind the policy as it stands is to give the district attorney information so that they can properly object, if they choose to object, to an inmate being paroled. And the logic is that it comes from the need to have access to information to object. As we discussed yesterday, I don't know this for sure, but my guess is that probably no inmate in the history of incarceration in Georgia has ever objected to their own parole, right? And so I think that's where this comes from, and at least, in my opinion, it's appropriate to maintain it that way. We did have discussion about that, and it was something that was brought up.
Any follow-up, Representative Kendrick?
Yeah, a few things. So I understand the purpose for the bill. But all I'm asking is, will the inmate have the same information that we're trying to give the DAs under, like, do they already have that, or we're just expanding it just for the DAs with this bill?
No, my understanding is that they would not have the ability to make the request to Department of Corrections like a district attorney's office would to obtain that information.
All right, any other questions for the sponsor? All right, hearing none. Is there any? I know that we received testimony in subcommittee, and Chairman Reeves has characterized the recommendation of the subcommittee. But I want to open it up. Are there any witnesses here today want to offer comment on House Bill 885 as amended, the substitute that's before us? All right, hearing none. At this point in time, I'll entertain a motion.
Move to pass.
There's a move to pass on LC 289677S, House Bill 885, committee substitute. Is there a second? All right. Motion and a second. Are there any proposed amendments? Any questions? Further discussion? Yes, Representative Kendrick.
So before we take this vote, I want to be very, very clear that currently, under state law, we are trying to give the DAs more information of confidential state secrets, but currently the inmates don't have access to the same information.
Well, we did hear in subcommittee the inmates are on notice of it because of the inmates' involvement potentially in the incident, but there was also discussion about an inability to maybe keep track of documents after the fact, or lack of availability to review the report. The issue, though, as I recall the discussion, was that this is matters of parole, and so it's under parole consideration for what would otherwise be a state secret, and based upon that, full information or a means by which statutorily to provide information to DAs was I think that, I don't want to speak for the sponsor, but I think that was the interest in bringing the legislation. All right. Any further discussion or questions? All right. Hearing none, all those in favor signify by saying aye. Aye. Any opposed? No. All right. The ayes have it, and the bill passes on to rules. Representative Petrie, I know you have to go, but we are going to have rule sheets in my office. If you would this morning, or maybe you've already done it, if you would complete that and get that and drop that off with us, we'd appreciate it.
Thank you, Chairman.
Thank you. All right. We'll next move on to Representative Setzler's House Bill 911. Chairman Setzler.
Thank you, Mr. Chairman, members of the committee. House Bill 911 is a bill that closes an important loophole that's been left in law. Starting in 2009, when this committee passed and created Code Section 16-6 5.1 in its close to its current form, prohibiting inappropriate sexual contact between teachers and students, medical personnel and patients, probation officers and probationers, and the like. A loophole was left in place that didn't prohibit foster parents from having inappropriate sexual contact with their foster children, their own foster kids. As we know, there are 12,276 foster children in our system as of this week, and this loophole, we believe, closing this important loophole in making inappropriate sexual contact between foster parents and foster kids mirror exactly that kind of contact between teachers and students, where if it's a touch, it's a high and aggravated misdemeanor consistent with sexual battery, and if it's intercourse or something more serious, it's a 1 to 25 felony with sexual offender registration, and that whole series of treatments consistent with the way we treat teachers, probation officers, medical professionals, and the like.
All right. What was the recommendation from your subcommittee?
It passed out unanimously, Mr. Chairman. There were a couple clarifying amendments that further clarified this issue, that it applies to foster parents and their own foster children, and those were welcome amendments, giving us the substitute you see before you today.
All right. A few questions. Representative Kendrick.
I'm actually using the microphone. Yeah, all sorry about that. Thanks, Mr. Chairman. I think our subs that we were handed are missing pages, and so we're missing pages 2 and 3 in the subs that Representative Kendrick and I are looking at. So we'd like to just verify, because I think we made some amendments yesterday. We just wanted to see that those were in there.
Yeah, we'll suspend on that. Thank you for pointing that out, and we will come back to that. If it's all right, we'll just suspend on House Bill 911 right now. So what I'll do is I will ask Vice Chairman Reeves to fill in for me as I present House Bill 941.
All right, thank you, Mr. Chairman. 941. Why don't you tell us about your bill?
So House Bill 941 was requested by the Attorney General's office. This legislation would allow for peace officer classification for investigators who are working in the AG's office. It was identified as there was a need in this area because of certain investigators would need to have peace officer powers. We had some very helpful discussions offline that led to the definition of peace officer that I know Mr. Bodie, Representative Bodie, brought to our attention and a few others. And so the substitute that's before you, LC 289666S, is a reflection of that amendment. Be happy to answer any questions.
Does anybody have any questions for the author of the bill? And Chairman Setzler, do you want to give a real quick subcommittee report?
As quick as I can give, Mr. Chairman. Yes. There was
A big R, really quick.
Exciting times for us here. Mr. This was favorably reported by the subcommittee. There was some discussion by the AG's office about the kinds of circumstances that gives rise to this bill. Some very practical things that for some otherwise very simple procedural things, they have to reach out to law enforcement, and it becomes a real impediment to doing basic things in important cases, and it was favorably reported, Mr. Chairman.
Thank you. Are there any questions or discussion on the bill? Seeing none, are there any amendments on the bill? Seeing none, is there a motion on the bill? Is there a second? Okay, there's a motion and a second. All those, or I guess I should technically ask now, are there any amendments? Seeing none still. All those in favor of the passage of House Bill 941 LC 289666S, vote by saying aye. Aye. All opposed? Bill passes. Mr. Chairman, you can get your form signed.
I'll know where to find them.
I'll be happy to sign them.
All right, very good. So we'll go ahead and move on now to House Bill 488. So Representative Momptan, if you would like to present where you are, that would be fine if you want to hit your button.
Though I don't know if y'all need this foam, but the foam is now missing. I'll place the foam on the table. Thank you, Mr. Chairman. Can you hear me? Is it?
All right, you're
on. It may need the foam, but it keeps foam. All right, can y'all hear me?
Yes.
Okay. Thank you, Mr. Chairman. Today I present to you House Bill 488. This came through the Reeve Subcommittee. What this bill intends to do, and a sheet here, let's see, and I'll kind of give a synopsis quickly. It creates a new offense of organized retail theft. It addresses property taken from one or more merchants over the course of 180 days in certain amounts, currently over 20,000, and shows that the intent to sell the merchandise that is stolen. Let's see. We'll go through the sections. Start with Section 1. Section 1 under starts line 12. Requires merchants purchasing store gift cards from individuals on the secondary market to record those transactions. It holds these merchants who are performing the same action as pawn shops to the same standard to which pawn shops in Georgia are presently held at the state level. It provides a consumer protection to aid victims of victim-assisted fraud in investigating the crimes perpetrated against them. And this section will aid law enforcement and retail loss prevention investigators in their pursuit of these bad actors. Section 2, we remove the word new from the definition of retail property in the retail fencing section, so we kind of encompass the goods that we're looking to capture. Sections 3 and 4, this is language as talked about yesterday by Representative Bernal at the request of the Clayton County DA about the first no-low contingent charge. Section 5 here creates the new offense of organized retail theft. taken from one or more retail establishments over a period of 180 days over $20,000 with the intent to sell merchandise for monetary gain. And as a synopsis, Mr. Chairman, that's the bill.
Thank you. I will recognize Chairman Reeves now to give a subcommittee report.
Thank you, Mr. Chairman. This is one of those bills that we debated thoroughly in committee and spent a lot of time on, and obviously, as many people up here know, we spent a much more significant amount of time offline working on this bill and trying to achieve the best balance of what we're trying to do. And this is really an example of what we do in this committee and in the General Assembly, of identifying where we are in time and in the world and what is going on in criminal enterprises, and making sure that we are developing laws that law enforcement can use that's on par with crime in 2020. And we've had a lot of testimony from retail entities and representatives from retail places about the scheme that goes behind these stored value cards, and how this is working, and it is obviously very significant. I will say that we have crafted a criminal statute that contains a significant number of elements that would have to be proven in order for this charge to stand up in court. There are a significant number of things that would have to be shown by the prosecution in order to sustain a case for this. And so we've taken seriously creating a high burden for that. And we've also created an extremely high dollar threshold amount of $20,000 minimum in order for any of this to apply. And I think that what that demonstrates is that this entire concept is going after these very elaborate money-making schemes that are going on in our state at a lot of our retail establishments. And the range that we have come to, some of the controversy behind the bill is that we have established a sentencing range of 5 to 20 years. But I believe that range is consistent with the demonstration of the egregious conduct, the premeditated nature, and the conspiracy behind this criminal scheme. And so I think that we have hit the right point with that. We've also used this opportunity to shore up a couple of other things as it relates to our theft by shoplifting, and I also want to thank the representatives from GACTL for bringing to our attention the opportunity to put what I refer to as the cushion language in a mandatory minimum language that gives the state and defense attorney the ability to make an agreement to sentence below that in repeat and recidivist shoplifting scenarios. And I think that that's good policy and something that when this committee has the opportunity to be in a code section and look at, it's a worthy discussion to have. So thank you all for that. There were several attempts to amend the bill, and other than one amendment by Chairman Setzler, none of them were successful. But I think this is a very clear policy, and I think the committee has vetted this as thoroughly as any bill that's come through my subcommittee this year.
All right, thank you. And it received a due pass recommendation from subcommittee, and I'll recognize looks like there are a few questions for the sponsor, so I'll recognize Representative McLaurin.
Thank you, Mr. Chairman, and I want to express again my gratitude to Subcommittee Chairman Reeves for allowing me to participate in the ruckus yesterday. The chairman noted that there were a number of amendments that were attempted by my colleagues and none were adopted. I want to zoom out now that I'm a fully documented member of the conversation and just make a note that the crime that has been described to us is a crime in which people steal items and then return them for store credit. And the reason they return them for store credit is because they don't have receipts. We're talking about a board-level decision by retailers in the association to allow returns without receipts in order to protect customer goodwill. That is the policy reason in the private sector for these board-level decisions to allow such returns. What we are being asked to do is to subsidize the goodwill of large retail corporations by way of the state of Georgia's criminal law. If you do not lock the door to the front of your house, you should not be allowed to ask the legislature for a 5-year, again, small letter mandatory minimum to keep you from having to lock your door because occasionally you do like to allow your neighbors to come in freely. That, I think, is bad policy. And unfortunately, because we didn't make any of the modifications that we asked for, to take it down from 5 years, to make a knowingly standard for the scope of the criminal enterprise, I'll point out the subcommittee chairman's language. He said, or the intentional nature of this. It is intentional for the organizers, but as the minority leader noted yesterday in subcommittee, there are going to be people swept up into this if they are runners who don't know the scope of the operation. I did some Westlaw searching, and unfortunately my fingers weren't fast enough, but as we were moving on from the conversation, juries are allowed to consider their sort of Price is Right, off the cuff, ordinary knowledge of the value of items when they decide how much an item is worth for the purposes of reasonable doubt standards, sufficiency of evidence. So we're not talking about a world in which prosecutors have to make an Excel spreadsheet and copiously document all of the different values of items in order to get to a $20,000 threshold. I mean, anyone who's been in state courts, and granted, I don't have as much criminal experience as the chairman of the committee do, but we're talking about a situation where prosecutors will be able to prove up these cases. They will be able to prove up, if you walk into a warehouse and you see the array of items listed, that there's constructive knowledge that you get to $20,000. So I don't have that concern. What I do have concern about is, even if they're probated sentences, we are vastly expanding criminal law to solve what should be a personal responsibility private sector problem. Thank you.
All right, I don't think there are any other questions for the sponsors, so this is a good segue into just discussion about the bill. So I'll recognize Chairman Setzler for any comments.
Thank you, Mr. Chairman. I would like to thank the bill sponsor as well as the subcommittee for addressing an issue I think is a critical issue that deals with protecting consumers. We recognize this issue of retail card theft and fraud is something that impacts our retailers profoundly, and it's the growth of this and the difficulty of getting at this issue that really gives rise to the underlying bill. The amendment, which is lines 69 through 64 of the bill, recognizes that consumers themselves are oftentimes caught up in this in ways that they don't have an easy means to get addressed by law enforcement or potentially by the retailers from whom they buy these cards. So what this does is it creates a provision where if a member of the public, a consumer, is stolen from through this theft that involves a stored value card in excess of an aggregate of $500. It's not a $100 card, $50 card. It's $500 or more. Then law enforcement would be required to request the information from the retailer, which really only the retailer themselves have. Once that information is in the hands of law enforcement, they then are equipped to make the reasoned judgment whether there's sufficient information to go pursue a criminal case, which in many cases there would be, in some cases there would not be. But it creates a structure where members of the public who are by the millions losing out to these kinds of schemes also have a means of redress. So this does not just affect large retailers or medium-sized or small retailers. It also very importantly helps consumers.
All right, Chairman. Actually, I'll hold on the Vice Chairman. Is that Representative Gravely? Representative Silcox, Chairman Silcox.
I was just going to respond. Thank you, Mr. Chairman, that I think it's important, particularly in the city of Atlanta, where we've had a really large increase in the amount of retail crime, and it is a known fact that the Atlanta police force is not fully staffed. It's important for business people, particularly small business people, to know that the legislature and law enforcement are behind them in their endeavors to try to maintain their businesses.
All right. Any other comments or questions? All right. I will give the subcommittee chairman's time here to conclude.
Thank you. And I just wanted to, I appreciate you, Representative McLaurin. We can't lay this at the feet of a board of a corporation. I mean, it's a benefit to all of us that they, we had testimony from the Home Depot and their return policy and the deliberacy behind that and how that benefits consumers. And if there's anything that we know, I mean, criminal enterprises are sophisticated and they're sinister. And they will take advantage of, they'll look for the crack, get the fingers in, and pull it apart as far as they can and expose it. And I think that's what we've seen here is that this new, I mean, it's not a new concept. The gift cards have been around for a long time now, but it's in the last probably 5 to 10 years, they've become almost like a currency, right? And so with that, we've seen the development of this, and I don't think that we can place that at the corporate board. Stealing is stealing, and while there very well may be a civil remedy for a theft, there's also a criminal accountability for that. And I think that this is an appropriate response to the sophistication and the sinister level of what goes in to essentially pulling off this scheme, and not just pulling it off, but pulling it off where we really get to the high dollar level. And I think this is good policy. I think that we've created a burden that is not easy. As a former prosecutor, I can tell you this would be a tough case to put together. And I think that the reality of it is that we're only going to see this statute be used in these very specific instances where the evidence is overwhelming. Otherwise, I think that there are probably many other currently existing criminal codes that will cover a lot of things. But this is a very dedicated and purposeful intention, and I think that it will be used that way. And so I do ask for the committee's favorable support of the bill today.
All right. I know we had extensive discussion. We received a great deal of testimony and considered several amendments that were proposed in subcommittee, but does anyone in the audience today want to speak further about this bill? All right, hearing none. All right, so at this point in time, the chair will entertain a motion. All right, there's a motion due pass on the committee substitute to House Bill 488 LC 289676S. Is there a second? There's a second. All right, any further amendments? All right, hearing none. Any further discussion from the committee? All right, hearing none. All those in favor signify by saying aye. Aye. Any opposed? No. All right, we will go ahead and take a hand vote. All those in favor, if you'd please raise your hand. 1, 2, 3, 6, 8. All right, and all opposed? 8 to 5. The bill passes. It passes on to the Rules Committee. Representative Momptahan, if you would just fill out a Rules Committee form before you leave, great, and just leave that with me. I'd appreciate it. All right, very good. So we now have copies of, we'll move back to House Bill 911, which we suspended on previously, and the chair will recognize Chairman Setzler to continue. Does everybody have copies of 911? Okay, complete copies. Thank you. All right, so we'll go back to Chairman Setzler to present his bill.
Thank you, Mr. Chairman, members of the committee. We had gotten into HB 911, again, a bill that seeks to address this issue of prohibiting inappropriate sexual contact between foster parents and their own foster children. I appreciate some of the amendments in subcommittee that clarified and make sure it applies to foster parents and foster children that are legally placed within their care. That amendment was added by the subcommittee. And as I began to allude to, this language tracks Code Section 16-6-5.1, which last year was amended, I think, in a very positive way to create 2 tiers of crime. One which involves essentially touching outside the clothes, akin to a sexual battery. That is a high, even if there were supposed consent, there is no consent here. That becomes a high aggravated misdemeanor because of the status of the foster child and the care of the foster parent, much like a student and a teacher or a probationer and a probation officer. And then if there's more serious sexual contact, intercourse, and the like, it is a 1 to 25 felony, as it is under current law in those other settings. That's the bill, Mr. Chairman.
All right, thank you. And this received a due pass recommendation from your subcommittee, correct?
From the Reeves subcommittee.
Okay. All right, and I want to thank Representative McLaurin for pointing out that we now have the pages with the operative amendments, and the amendments appear to be consistent with the amendments from subcommittee. So thank you for pointing that out. Does that look right to you? Yes, sir. All right. Okay. Any questions for the sponsor? All right, very good. Is there any public comment on House Bill 911? This is LC 289665S. This is committee substitute. All right, seeing none, we'll entertain a motion at this time. All right, there's a motion do pass by Chairman Reeves. Is there a second? And there's a second. All right, any amendments? Any further discussion? Hearing none, all those in favor signify by saying aye. Aye. Any opposed? All right, Chairman, it passes. It's on to Rules Committee. All right. House Bill 528 is on the agenda for today, but that is actually not passed out of the Reeves subcommittee yet, so that was a mistake that was included on here. That is continues to be in the Reeves subcommittee with anticipated hearing next week. So the remaining bill then on the agenda here is House Bill 984. Representative Burchett, if you would hit your button. All right, we'll recognize you at this time. Thank you.
Thank you, Mr. Chairman, committee members. This is House Bill 984. It was in the Reeves subcommittee. I'm working off of substitute LC 289675S. And this is a revision to our criminal procedure code. And some of the things that it does is it gives the opportunity for the court to have a little more time after to hear or to issue an order or hear after a remitted or after direct appeal. It also changes how we compute a sentence for defendants on bond that are awaiting appeal. It's carved out some exceptions in this computation of the time served language, and I've got Jill Travis and Ashley Merchant here from Gactyl that'll help answer some of these questions. But essentially, that's what the bill does. Gives defendants credit for each day incarcerated, no matter what type of facility they're in, pre-trial or post-trial.
All right, thank you. And just for some clarification, I know we passed it out of the Reeves subcommittee yesterday with an understanding that we would wordsmith some of the language, and that took place in the hallway with participation by Ms. Merchant, Ms. Travis from Gactyl, Mr. Smith from PAC, as well as some other helpful advocates who were able to help us with the language. So that's what's before you now. All right. Are there any questions for the sponsor? Okay, hearing none, I'll give Representative Reeves an opportunity to do a brief chairman's report.
Thank you, Mr. Chairman. Very briefly, this essentially addresses three, it more or less provides a little bit of clarification for three matters that all relate to sentencing. And the first of which deals with when a motion to modify a sentence is filed. Typically, you have a year to file that, and if you would typically want to wait towards the end of that year to demonstrate good behavior and good conduct in order to be able to, in good faith, argue that that person would be deserving of a modification of their sentence. And the way the law has been interpreted right now is that the motion has to be filed and the court has to hear it and it has to be ruled on within a year. What this change will do will clarify that you just have to file it. There are a lot of courts, especially in rural Georgia, that do not meet that often. And so this will help secure more clarification on that. The Part 2 of the bill deals with when a person has been convicted, but a defendant has been convicted and has filed for a supersedious bond, which would mean that their sentence would be withheld until sentencing would not take place until the Court of Appeals has ruled on a matter. And once they rule on that matter, and if they do not rule favorably towards that person, this clarifies how the process would go for the notification of that person that their sentencing will begin. And so, and it creates the burden for the state to notify, and that was one of the words that I believe we changed. we had some previous securing the commencement, but we changed it to notify the defendant. And finally, Section 3 clarifies what happens when you have multiple charges and probation violations and you're serving time in the state prison and the county jail, and what you get credit for. What this really does is it codifies what is, I would say, about a 98% practice as far as what actually happens in court. And I think that this makes common sense and is good policy. And it also, there was a lot of input from Judicial Council and the various judicial groups. And there are a few carve-outs on lines 64 through 70 where they have asked to retain some exceptions for certain things. So I'll be happy to answer any questions as well.
All right, I don't see any questions. Is there anyone in the audience here who's interested in providing input on this bill? All right, hearing none, go ahead and consider a motion at this time.
Move to pass.
All right, there's a move to pass. Is there a second? Second. All right. Any further discussion or amendments? All right, hearing none. It's House Bill 984, Committee Substitute LC 289675S. All those in favor signify by saying aye. Aye. Any opposed? All right, we're adjourned. If you would please check your schedule. I expect we're going to have several announcements today. Committee schedule have several announcements today for subcommittee and full committee meetings for next week. Thank you.